Hi, my name's Steve Cowan. I'm the son of a lawyer, the grandson of a lawyer, and my son is studying to be like me, a lawyer. I graduated at the top of my class from the University of San Diego School of Law in 1987, cum laude, and was a member of the Law Review. I passed the bar on my first attempt and was sworn in as a lawyer by Judge Beard at the El Cajon Municipal Courthouse in January of 1988. In my 32 years of practice, I've devoted considerable time to business reorganization issues and in addressing debt problems faced by individuals, families, and businesses. My practice has been limited to almost exclusively debt reorganization matters since 2007. In this short video, I'd like to provide an overview of the Small Business Reorganization Act, or as we lawyers refer to it, the SBRA. By the end of this video, you'll no doubt, like me, believe that for the owner or owners of struggling restaurants and other businesses, that the SBRA is manna from heaven. A federal district court judge, in his written ruling addressing an SBRA matter, had this to say about the Small Business Reorganization Act. Quote, had Congress been given a crystal ball with the power to see what the world is facing today, including the severe disruption to our nation's economy and its impact on small businesses, Congress likely could not have drafted a more effective set of mechanisms to help these businesses reorganize and hopefully survive. The Small Business Reorganization Act is a series of laws that give to eligible business owners powerful tools to permanently eliminate debt, reduce amounts owed on secured debt, reduce interest rates on debt, extend payment terms, and be just about as creative as the business owner needs to structure a plan of reorganization that keeps the business open, operating, and its employees employed. The SBRA was not enacted into law as a result of the COVID pandemic. The SBRA was passed by Congress and actually enacted into law in August of 2019, 6 months before the arrival of the COVID virus. By its terms, the SBRA became effective in February 2020, just as the COVID virus hit. Talk about just in the nick of time. Income is down, and there is no turnaround in sight. Right now, the path to staying in business is not trying to get back to pre-COVID income levels. The key to success is to permanently reduce post-COVID expenses enough to regain pre-COVID profitability. It means you have to permanently decrease and or eliminate expenses. Although not passed in response to the pandemic, nothing, not the Paycheck Protection Program, not Small Business Administration, emergency loans, or any other tool available to business owners gives to struggling business owners the power to permanently reduce the amount of debt owed and permanently reduce monthly debt payments, nothing like the SBRA. Achieving these results was theoretically possible in the past through business reorganization under Chapter 11 of the Bankruptcy Code, but the benefits came at a huge price. Sure, under a regular Chapter 11 case, a business can reduce its debt load and its monthly payments, but a number of significant hurdles had to be cleared. First, the business owner basically had to agree to give up all equity and ownership in the company. Second, arcane rules regarding approval by at least one member of each impaired class had to be met. Few owners, in exchange for debt forgiveness, are willing to give up management and control of the company. And even fewer creditors are going to sit by and allow that to happen. So getting the consent of one member of each impaired class has proven, practically speaking, to be next to impossible. If you are a nationally traded company like General Motors, the equity holders can be easily wiped out, leaving the company's ownership in the hands of its debt holders. But individual shareholders in a publicly traded company are not the same as the individual owner or owners of a small restaurant or other business. Congress, as a result of pressure from groups like the National Association of Consumer Bankruptcy Attorneys, of which I'm a member, changed the rules to make it much easier, some say too easy, for qualifying small businesses, and we will discuss eligibility requirements in a moment, to, as we say, get to the promised land. First, there is no requirement under an SBRA reorganization for the owners to give up equity or control. None, zero. No buy-ins or buybacks or new value. Current ownership stays in possession during the process. They remain in possession and in control when it's over. Second, pursuant to rules that are very business owner friendly, a judge can cram down a reorganization plan on all classes of impaired debt, whether or not any of them agree. What does this mean practically? All unsecured debt wiped out. If equipment is worth $20,000, that's the new contract, regardless of how much was owed prior to filing. High interest rates, new interest rate 6%. New payment terms, done, whether the creditors like it or not. The SBRA also changed a number of onerous administrative requirements that prevented smaller businesses from reorganizing successfully under a regular Chapter 11 case. And again, when I say reorganizing, I mean permanently eliminating certain debts, permanently reducing the amount, interest rates, and payment terms on other debts, and permanently restructuring the payment of certain other debts that otherwise by law had to be paid immediately, such as the IRS or employees for back wages. The first administrative change is the role of the trustee in an SBRA case. In a regular Chapter 11 case, the trustee is not your friend. In an SBRA case, they are specifically required to mediate disputes between the small business owner and his or her creditors with the goal of reaching a consensual agreement as to the handling of a particular debt. The leverage of a Subchapter 5 trustee is significant because the rules for when a judge can cram down, that is, force a creditor to accept renegotiated terms, are very small business friendly. Sometimes I think the rules are too small business friendly and that Congress may have to step in and tighten the rules once Congress sees how much in losses banks are forced to absorb. In a nutshell, Congress did not foresee a pandemic where so many businesses could take advantage of the SBRA to the detriment of the banks. Congress passed a law thinking banks would absorb, say, $50 million in losses a year. But the way these rules are written, if every business eligible for them took advantage of them, the losses could be in the billions. Okay, and there are plenty of businesses eligible. Recent news reports predicted 1/3 to 50% of all restaurants will fail as a result of the pandemic. If every one of those businesses currently set to fail put the SBRA to work for them, my estimate is that the failure rate would go down by half. The cost of saving those businesses, however, is measured in significant losses to banks. So getting an SBRA case on file as quickly as you can first means that the law changes, you're grandfathered in. Second, once the debts are reorganized, they don't bounce back. If income returns to pre-COVID levels with debt permanently reduced, business value and owner income go up significantly. So to maximize the benefits of the SBRA, it is best to file when the restaurant or other businesses' fortunes are at their lowest. Talk about a cloud with a silver lining. The SBRA can, on a dime, change the bleakest of situations, business closure, to the business regaining and remaining profitable in the short term. And then when income comes back, that business and those business owners will enjoy supercharged profits and business value because the debts were renegotiated down at the business's low point. So if you are thinking about shutting the lights off for good at your restaurant or business, being in that situation may in fact be a blessing in disguise. Now let's talk about eligibility. There are 4 conditions that have to be met in order for a business to qualify for the SBRA. First, the individual if they are a sole proprietorship, or the company if the business is done as a corporation, limited partnership, or limited liability company must be actively engaged in business or commercial activities. Second requirement, the business cannot have more than 2.7 million in debt. But note, this amount is increased to 7.5 million in debt until April 2021 due to the pandemic. Third, not less than 50% of the debts have to have arisen from the commercial or business activities of the company or individual whose business is to be reorganized. Fourth and finally, businesses whose primary activity is owning and operating single asset real estate do not qualify, and neither do publicly traded companies. All right. The active business requirement is easy to meet, except in the most exotic of cases. Congress enacted debt limits because they realized how powerful the debt reduction tools are under the SBRA and wanted to limit the number of companies that would qualify, in part to limit the economic impact and losses to the banks. The third condition, 50% of the debts arising from the commercial or business activities of the company can be problematic. Trust me, banks don't want businesses taking advantage of the powerful tools available under the SBRA. So the paperwork has to be put together and the debts documented precisely to blunt attempts by the banks to disqualify the business from benefits available under the SBRA. Okay, now getting disqualified doesn't mean there isn't a reorganization option. There is a standard Chapter 11, but permanently eliminating debt, permanently reducing debt, and permanently restructuring debt is by a magnitude of 100 easier if the reorganization is done pursuant to the rules applicable to qualifying small businesses under the SBRA. We hope you enjoyed this video. Please check our video library and blog for other topics that may be of interest. If you would like to discuss your company's particular situation, call or fill out the contact form. We also offer webinars. Check the website for details on upcoming dates and times. Finally, talk with a lawyer before you make a decision on the SBRA. Each particular case is specific. The information in this video is designed to educate, but is not designed for any particular case in particular. All right, thank you very much.